Good.
Right. Ladies and gentlemen, good afternoon. Today I'm glad to start the session relating to tackling corruption and money laundering in international arbitration. I have my colleagues here, whom you could see and whom you could hear, for the purposes of the smooth handling of this session. At the moment, we are the only one who could speak, but if you want to participate in a bit of a more active way, you might want to either raise your hands or write in the chat or ask me to allow you to speak. Given that we have quite a limited number of the participants, we can, I think, allow your entry into the discussion. Now, as I said, I'm glad to introduce you my colleagues. Today, we have Tatiana Minaeva, who is the partner in commercial disputes from the RPC law firm. She is joining us, as far as I understand, from London, from the UK. And I also have Marc Goldstein, who is the fellow of College of Commercial Arbitrators, Chartered Institute of Arbitrators. He's in charge of the MJG arbitration mediation. And I think he's joining us from New York. And I'm Alexey Dudko, the partner at Hogan Lovells, Moscow, of the International Dispute Resolution Practice. So we'll discuss today quite a topical issue related to the quite interesting issues on tackling corruption and money laundering. I'm sure you, as practitioners, joining us at least once faced this during your practice. So we'll discuss the trends, the models, and the case law, as well as the standards of proof. We'll, I think, start with some brief introductions as to the problems we think are interesting, and then we'll welcome your questions and the discussions as we speak. I think that Tatiana might want to start with the heavy lifting, which is the burden and standards of proof of corruption for delegation in international arbitration. I could say that we have also quite a distinguished audience today. I know that Vladimir Khvaley, who is joining us, he participated in the corruption and money laundering international arbitration, a toolkit for arbitrators, which was developed recently. So it will be interesting also to see what is used and not used in practice. And I'm sure we'll have some lovely discussion in due course. Tatiana, please.
Yes, thank you very much, Alexey. So I will start and I will focus my talk on burden and standard of proof of corruption and fraud allegations in international arbitration. So international arbitration is mainly what I do, and I focus my practice on commercial and also investor-state arbitrations. And based on my experience, and actually I think overall practice, is that it's more increasingly that respondents use allegations in corruption in international arbitration. And it's a rather interesting and topical question, because corruption is it's a very thin line between civil and criminal law. And these allegations, they raise various questions relating to public interest, and they rather go beyond the party's autonomy. And we know that arbitration is based on party autonomy. And so, for example, it's a very complex question whether arbitrators have power to raise and investigate corruption on their own initiative, so a sponsor. Allegations of corruption raise also other questions, such as who has a burden of proof and what is the standard of proof. So therefore, I will start with the first big issue: what is the burden of proof? And I should say that the dominant trend is that the burden of proof lies on the party that allege corruption. So if corruption takes place, it's very unlikely that there are paper trail exists. So most evidence is circumstantial or is based on what witnesses say. And combination of this lack of direct evidence and also tribunals' rather limited power and ability to compel production of documents in arbitration has led the scholars to discuss the shifting or reversing the burden of proof. So asking a person, a party against whom the corruption allegation are raised, to disprove these allegations. But this shift and this idea is rather debatable, because there is a view that this should apply only where the standard of proof is very high. So this restricts the cases where the party alleging corruption and that has no evidence at hand tries to shift the burden of proof on the other party. For example, when the party alleges corruption in the hope just to avoid the performance of the contract. And this, of course, brings me to the next big issue, is actually what is the burden of proof, the standard of proof. And international law does not provide any clear guidance on these issues, and the tribunals adopted rather diverse approach. And the awards are rather inconsistent. And I will just provide a summary, a very brief summary of these conclusions. So I should say that there are two general approaches to the standard of proof. The first one is the clear and convincing evidence standard, which is a heightened standard of proof. And the second one is the reasonable certainty, or it is also called red flags, connecting the dots, which is a lower standard of proof. In a nutshell, when we are speaking about clear and convincing evidence, so the rationale behind this standard is that corruption, if it's proven or if it's found, has very serious consequences for the award. So if it's found, the claim is dismissed and the claimant has no protection. And this approach was adopted, for example, in cases Fraport versus Philippines and EDF versus Romania. Another standard, reasonable certainty, is based, the rationale behind this standard is that it's very difficult to prove corruption, that corruption very often is based on evidential circumstances. There are just red flag, indicia of corruption. And I know that Alexey will be speaking about Metaltech versus Uzbekistan case. This case is exactly where the tribunal adopted reasonable certainty standard and acknowledged that it lacked its jurisdiction because of that. But some tribunals, they avoided addressing corruption at all by reaching decision declining the jurisdiction based on unrelated grounds. For example, in one case, which is called International Systems and Controls Corporations versus Industrial Development and Renovation Organization of Iran, the tribunal permitted belated submission of evidence on corruption, but bypassed any findings, legal findings on corruption, by holding that it lacked jurisdiction because the claimant didn't prove its ownership interest. So what to do? And I would propose to the audience a few solutions which we can discuss, maybe two solutions, I would say. First, I'm personally in favor of shifting the burden of proof and drawing adverse inferences. So the opposing party that is subject to allegations of corruption, I think, should bear the burden of proof of disproving the allegations. This should be considered only when the party alleging the corruption has prima facie evidence of corruption. So not only when very really strong evidence exists. So the party which faces allegations of corruption, it has maybe better position to disprove this allegation because it can have access to its bookkeeping records, or it can explain the rationale behind some services agreement. So this might be very helpful in the circumstances where tribunals, they have limited powers to compel the party to produce the documents or order like detailed disclosure. But if the party fails to produce these documents, then the tribunal should should of course draw adverse inferences. And this should be the case when there are indications that some document exists, but the party still refuses to produce this document. Then it's clearly the tribunal should draw adverse inferences from that. My second proposition, and I should say I'm in favor of lowering the standard of proof, and I would put greater reliance on circumstantial evidence. And indeed, allegations of corruption in international arbitration, they are not the same as allegations of corruption in criminal proceedings where people's lives are involved. So the clear and convincing evidence standard might not be appropriate here. So I would be in favor of this lowering standard, like to balance of probabilities, which is a standard which applied in civil actions in common law jurisdictions, and to rely more on red flags and indicia of corruptions. So finally, I propose that the parties should know in advance what standard of proof the tribunal will apply, because it will affect their outcome. So this is briefly from my side. Thank you.
Mm-hmm. Thank you very much. Thank you very much, Tatiana. It's obviously I think largely in line with what the practice is developing. Although I know that, for example, in this toolkit about which we discussed, there was a more reference to the applicable law and the standard of proof regarding the allegations of corruptions in relation to the applicable law, also connected to a certain extent to the seat of the arbitration. So I think that's a bit of a challenge, that you identify a unitary approach in quite a diverse environment, which the world of international arbitration currently is. So from this perspective, we could perhaps discuss it later on, but Marc wanted also to bring some models of order in this current quite a lot of chaos, I have to say, in relation to this issue, because there are quite a lot of undercurrent streams and opposing views, although there are some, pioneering uniform instruments such as the toolkits and other and conventions, but still it's a bit of a it's a wild terrain. So what's your proposal in this respect, and how do you assess the practice as a US practitioner?
So this is the floor to me, Alexey?
I hope so, Marc.
Oh, okay.
Unless you disagree.
Well, Tatiana brings us in on the issues of allocation of burden of proof and evidence at sort of the graduate level course for the practitioner. Maybe I'll go back to the basic level course a little bit, at least to start, because the first time I was exposed to this issue of corruption in international arbitration, I was not quite fully understanding what it was, and now that I know a little bit, enough to be dangerous, by the way, and as an American arbitrator, I'm a danger to Americans as well as to foreign parties. But you have different, what I call models of corruption, and for the practitioner just starting to understand how corruption has an impact in international arbitration, it's good to understand what those models are. And we won't discuss all of them in detail, but just think first of all, you could have a legitimate business transaction that is the subject matter of the arbitration, and the allegation of corruption is raised by, let's say, a host state or a state instrumentality that entered into a contract. It may or may not be an arbitration under a contract as opposed to a treaty, but the contention made by the state enterprise is that there was a corrupt procurement of the transaction or the investment, in the sense that the claimant made improper payments at some level to induce the state enterprise to enter into the transaction. A second variation on that would be the investment may well have been made without corruption, but there was corruption involved in the execution of it. That is to say, now, for example, let's say that there is a treaty-based arbitration and the claimant is claiming that certain taxation measures or whatever deprived it of fair and equitable treatment. Now a claim of corruption might be made, but it's not relating to the initial investment. It's relating to the way the investor carried on business in relation to the state over a period of time. So that's a second sort of model of corruption in the business dealings that we might deal with. A third, and we won't discuss this in detail, but it's good for those in the audience who are just being initially exposed to this area, is a corrupt transaction itself. That is to say, there could be an arbitration where the claimant is seeking to enforce what the respondent claims is an unlawful transaction. Of course, the respondent, having been a party to the transaction, is now in an awkward position, but it might be a successor government or a successor entity that purports to be conducting business on much more internationally acceptable standards, and wants to disavow the transaction entirely. So there would be an allegation of a corrupt transaction that should be denied enforcement entirely as a matter of international public policy. And of course, that would be very, very involved with the merits. And finally, you know, we shouldn't overlook, and we deal separately, I think, with questions of corruption of the arbitral process itself, which is a subset which we won't get into very much today, but you have issues about both arbitrators and experts who may have been unduly influenced either by payments or by threats by one or the other of the parties that are appearing in the case, and that is something that does occupy both tribunals and providers that are administering arbitrations. But what I'd like to focus on for my remarks going forward in this discussion is the first model, and the one that is familiar to many of us. And let's just conceive it as a transaction or a state contract or a concession or something that allegedly would not have been awarded to the claimant had it not been for the making of improper payments at some level of the organization that now are alleged by the respondent to have been the quid pro quo for awarding the contract to the claimant. Okay, and let's think about this, and let's call it for the moment. Let's call it bribery, and let's say what's our concern about bribery in international public policy? Is bribery always a bad thing? Well, after all, the bribery might have occurred 15 years ago, but the concession might have been of great benefit for the state, for its enterprises, for its citizens. It might have been, after the initial bribing that succeeded, the claimant might have done a very, very good job. So there are some questions to be addressed, and often are addressed in such cases. One, and it's a very important one, is should bribe payors, claimants who have made improper payments to secure a contract, should they be excluded from the arbitration process entirely? That is to say, for example, let's just take the ICSID system, for example, and say, okay, you're in an ICSID arbitration now, either because the contract chose that or because it's a BIT and that it was the standing offer was to have ICSID arbitration. The ICSID arbitration system rejects corruption as a matter of international public policy, and it is often argued in such cases at a jurisdictional stage that the claimant should not be permitted to avail itself of that system, and therefore, as an objection to jurisdiction, it is raised. Now, that's very important from a procedure standpoint, if you're in an arbitration, because after all, if it's recognized as a jurisdiction issue, and of course the issue is going to be very, very complex, it may be a 2-year process at the very beginning or more, limited to the issue of whether there is jurisdiction. And of course, that happens with many kinds of jurisdiction objections, but this one especially has the potential to take over and be not an issue in an arbitration, but an arbitration in and of itself on the single issue of corruption. Another question about whether bribery is bad is it only bad if it's successful? Now, bribery may be a way of doing business, but it may have absolutely no influence on the ultimate decision. And whether it does influence the decision to grant a contract is a very complex matter, and we'll come back to Tatiana's point about circumstantial evidence in that regard in a minute. Now, we have to bear in mind as well that the investor may have made an investment based on improper payments or alleged improper payments, but the case often exists, not only because there's been a breach of contract, but arguably because there have been violations of international law obligations of the host state under a treaty, and those are very significant allegations of violations of international law obligations. And the question that is faced in these arbitrations, should a state be excused entirely from its obligations under international law because the investor made an improper payment that may have been insisted upon? It's very it will always be a factual issue to be examined. Who corrupted whom? Where is the corruption? Of course, the state as a respondent trying to avoid a very significant liability wants to say it was the corruption of the initiated by the claimant upon some unwitting perhaps or now departed state agent. But the state, after all, the context is that the state allegedly has expropriated property or denied an investor fair and equitable treatment, for example, and is now trying to avoid the financial consequences of those alleged breaches of international law obligations by raising a threshold issue of corruption. And on this sort of tension, I capture it. There's a famous case in the corruption area, and many of you, I'm sure, have read it, called Eco Resources against Bangladesh, or Bapex was the petroleum entity of Bangladesh. And a very distinguished tribunal, and I noted what they said here, and I'm going to quote so you can think about it. The tribunal questions whether it can be the purpose of the fight against corruption to procure a profit to those who present themselves as victims of corruption, which is to say, a state enterprise or a state that has derived significant benefit from an allegedly unlawful conduct and a benefit from having taken property without respecting international law norms, and now says, well, we're privileged to do so because there was corruption on the other side. Now, I don't know, Alexey, do we have the ability to do a little poll question with our audience?
I think we're better off putting it, showing as to where we are in terms of the questions which are raised at a bit of a later stage, Marc, because we're yet to hear the where we are in terms of the reports and the interest and the discussion. Otherwise, I think we can be stuck with the polling, and it could take fine. The limited time which we have.
So rather than do an actual poll question, just in your mind, if you were raising your hands one way or the other, think about which way you would raise your hand. If the question were posed, should claimants who have paid bribes be entirely excluded from the ICSID arbitration system as a matter of international public policy? You might think yes, you might think no. Now, there are some sub-questions I ask, and this is just for you to think about this. One is, if that exclusion is an issue, must the question of exclusion always be handled by the tribunal as a preliminary issue, always, so that you must have a separate arbitration, in effect, about corruption at the beginning. And if you entertain that principle that it results in exclusion from the ICSID system, will host states be motivated to contrive claims of corruption in order to paralyze proceedings? Is it a perversion of international public policy, if you will, that it results in another roadblock to the effectiveness of the ISDS system, so to speak? And coming back to Tatiana's point on burdens of proof, should there be a very high bar for the claimant to cross at the beginning, or for the respondent, the respondent to cross at the beginning, to say prima facie there is corruption here that justifies an initial paralysis of the arbitration, ignoring the merits for 2 years? Should that have to be very direct proof rather than circumstantial proof in order to justify a separate jurisdictional phase concerning corruption? Now, there's one way out of this I'll mention, and those of you familiar with the Eco Resources case will recall that what the tribunal found was, well, this involved a state instrumentality contract, the petroleum gas entity, with the foreign Canadian investor of Canadian nationality. And since the arbitration clause, regarded as separate, was not itself alleged to have been procured by corruption, therefore it was not an issue of jurisdiction. The arbitration went forward, and it was considered effectively in conjunction with the merits, although there was a separate ruling on corruption, which many of you have read, issued early last year. But it was a way around the inevitability of a jurisdiction phase to say, well, if it's a contract and the arbitration clause has not clearly been procured by corruption, then prima facie the tribunal has jurisdiction under the arbitration clause, and the arbitration can go forward, and there's no question of legitimacy of the arbitral institution. Okay, now let me be fast here, because I don't want to waste too much time that others should have to comment and to intervene. But I just want to give you quickly, since I'm mainly an arbitrator and I think about procedural matters, a little bit of a procedural checklist, the kinds of issues that we think about, and those of you who are counsel often will think about in context of advocating for them. One that Tatiana mentioned, adverse inferences about circumstantial evidence, but think also because of the collateral consequences or threats of criminal prosecutions and damages to other business activities of the entities in other marketplaces, the significance of confidentiality orders and careful observance of confidentiality orders in the place in the arbitration, so that the arbitration doesn't become effectively a satellite proceeding in support of criminal prosecutions in other jurisdictions. Okay, that's one issue. A second issue to think about is, and Tatiana made reference to this also, what should be the role of the tribunal in gathering evidence? Now it's relatively straightforward to think about the tribunal gathering evidence from the parties, but what about beyond the parties? What about situations, as was the case in the Nico case, where there had been, in fact, very serious criminal investigations, not only in Bangladesh, but into the United States and in Canada? And should the tribunal be a party, if you will, to a judicial proceeding in the United States or in Canada or elsewhere, asking the courts to assist the tribunal in gathering evidence from third parties, and especially third parties who are themselves investigative bodies, right? Just imagine a scenario where an ICSID tribunal seated in Paris or in Moscow or whatever is now a party to a proceeding before a federal district judge in New York under our famous section 1782, which is our judicial assistance statute for foreign proceedings, saying we want the Federal Bureau of Investigation, we want the FBI file about the claimant. We want that complete file. In fact, we want a deposition in New York next month of the FBI bureau chief who was in charge of the investigation. Raises many, many issues, not only about the power of an ICSID tribunal to be conducting that kind of external evidence gathering in what is thought to be an autonomous system, but how should a court respond to that? And just one more comment, and then I'll stop because I want to come back to Tatiana's point about circumstantial evidence. Those of you who are familiar with the Nico case will have seen in its great complexity and its hundreds of pages of analysis of facts, that much of that analysis had to do with the respondent state offering circumstantial evidence. For example, saying, well, the law minister who offered an opinion that this was an appropriate transaction gave a very, very irregular legal opinion. And now we're going to go into all kinds of briefing back and forth about what the law properly was or should have been, and whether his interpretation was so irrational that one must infer that there must have been a corrupt inducement for that opinion because no rational justice minister could have so opined, right? I think that's a classic example of what Tatiana is talking about in terms of circumstantial evidence, where the claim is made that in the normal world, things just wouldn't operate this way. And you can infer from the fact that they did operate this way that there was corruption. But what it spawns then is a great deal of factual and legal debate back and forth about what is normal and what is unusual and what are the inferences from the way it happened. So I think that's enough. I'll be quiet, Alexey. Thank you very much.
Thank you, Marc. Well, it's really illuminating in a way to get the arbitrator's perspective here, because we from time to time sit as arbitrators, but mostly acting as counsel, and there's quite a big deal to hear what is the perspective of the arbitrators over there, and also many issues, because one which you've touched upon, I'll just briefly comment before I jump on to some matters which I wanted to bring to your attention, is that I think this was raised last year at the Paris Arbitration Week as to whether a party, who procures a contract by corruption means should be entitled to recover damages to the extent of the benefit conferred to the state, which could be, brought in each and every context of not necessarily an investment dispute, but also commercial dispute. So, what is your take on this? Because what happens, and in various matters, including those coming from the CIS, especially from Central Asia, is that with the states being in the low ladder of the corrupt index, states, the first defense is effectively corruption. And in the end of the day, it turns out to be that in many arbitrations, the claims were denied on the basis of corruption, which was effectively, to a certain extent, tolerated by the states and created some kind of convenient defense, depriving the investors of whatever rights they have. So this was, I think, an interesting debate and something for all of us to think whether, and this is a policy issue in the end of the day. And I don't think that at the moment there are, readily made answers to them, as there was a lively discussion. And you've raised it again, this issue, which is quite important. In the interest of time, and we don't have that much time. We have 50 minutes left, and we have to, to finalize in time. I just wanted to briefly discuss a number of matters which I think might be relevant to the issues of corruption and money laundering, because our topic is also money laundering. which obviously are important, I think, for this sphere. One, which is it's not a new case, but I've participated in it personally, and therefore it's quite important. It was one of the first, I should say, arbitrators which raised the issue of of the contracts tainted by corruption, which is the GNSS, or Global Nuclear Service and Supply Corporation, US against Technab Experts, which was a $1 billion arbitration, commercial arbitration handled in Stockholm quite some time ago, 2007, whereby effectively a claim for damages for termination of contract was defeated with reference to Section 33 of the Swedish Contract Act, which says that effectively, it's not allowed to claim under the agreements which are invalid, had the party known that in fact, it would have been invalid per se from the start, and it would have been inequitable to enforce the questionable legal acts, including those which violate the law. And I think the remarkable thing there, because it had to do with the corruption with the one of the Russian ministries, which turned out to be that certain individuals, they've instituted and put this claimant structure in place in the US, which had then subsequently made a contract with the Russian nuclear supply entity, which also raised the issues of national security, etc., which was terminated when the state started to control and was trying to understand the reason for the contract to be entered in the first place, that there were clear signs of corruption. And there was an issue with proving of this. And there was a permission obtained from the criminal investigator to bring the materials from the criminal matter handled in Russia to investigate corruption to the arbitral tribunal. Although the tribunal itself distanced itself from the criminal investigation going on in Russia, the evidence which was brought over there with the protocols of the investigation, interrogation of certain witnesses, etc., made it extremely suspicious as to the origin of the contract. And although it didn't reach the express conclusion based on the corruption defense, but it was effectively one step away from it, which resulted in the tribunal, probably in one of the first significant matters, refusing to enforce the claim, in which effectively was based on the contract procured by corruption. So it was a big shockwave around and for everyone. And since that time, of course, many things have changed, and the legal playing field related to the interrelation of arbitration and corruption has developed since that time. And also referring back to what Marc and Tatiana said, probably this impossible tension which the whole issue of corruption, money laundering, sanctions, what it's a separate issue, of course, has brought, has to do with the fact that, of course, there is a certain development, a moving of arbitration in terms of its, legal juridization, in a way that it's getting more in line with the usual legal proceedings. Yet it wants desperately to retain its independence and protect itself from the winds of the world. And this is the tension which creates all sorts of problems. The two matters which I want to briefly discuss with you, one has to do with the Kim versus Uzbekistan, the exit matter, whereby, returning to the burden of proof, the tribunal said that the claim by the Kazakh investor against the state of Uzbekistan was not proved under the standards of the Uzbek criminal law and under the standards of the Uzbek criminal procedure, because the daughter of the former president of Uzbekistan was not a public official in the meaning of the Uzbek law on state service, as well as in the meaning of the Uzbek criminal law. So that was the reference. in terms of what the tribunal relies upon without even going into the detail as to which exactly standard of proof has to be applied in that particular matter. That's one approach. On the other approach, which I'm also perhaps just flagging out the issues given the lack of time, I just wanted to refer to you briefly on the Belacoin versus Kyrgyz Republic. Also quite a problematic part of the world, but there effectively there were the allegations of money laundering in relation to a Manas bank owned by an investor who brought a claim in order to seek damages from the state for the imposition of the temporal administration, which effectively paralyzed his management of the bank following the revolution in 2010. Now, because there was a 4-year period whereby he couldn't exercise any control, he sued the country and alleged that the supervision amounted to the de facto expropriation. Now, the state in return said that, well, effectively the bank was used as a bit of a part of the Latvian scheme of money launderers involving this Kyrgyz bank. The tribunal, applying the standards of proof and relating to Tatiana's speech, says that because the Kyrgyz authorities themselves had not established the crime as a matter of Kyrgyz law in relation to money laundering, and the evidence which was presented to the tribunal was inconclusive, it ruled in favor of the investor. However, when the award was subsequently challenged in France, and there was a challenge brought to the French courts, the French courts took a slightly different view. They referred, notwithstanding and without being limited to the evidence which was brought in front of the tribunal, they said that, listen, we will not look at the Kyrgyz law standard. We will look in the international legal standards, and we will look at the situation as a whole. Therefore, we will consider the additional evidence which relates to the fine brought against the bank prior a couple of years earlier before the arbitration as the evidence of the money laundering activities. Then they reconsidered the evidence on their own, which was primarily, contested in the arbitration, and thought that that was sufficient to deny enforcement of the awards with reference to the international public order and the overarching needs to protect the legal order from money laundering activities. So, different approach, different standards, and lack of, I think, unitary background so far. That's perhaps the second best world we're living into, and but that's the reality. With this in mind, I will just pass on to those. First of all, we'll welcome questions in the remaining 7 minutes of our time. From the attendees, as well as maybe some comments from Marc and from Tatiana, if obviously there are thoughts rather than questions at this stage. Marc, perhaps you want to comment on and that, because I know what we just discussed before the conference. There's many issues. What is the most pressing thing which you also regard as an arbitrator, given our discussion and the comments you have heard so far?
Well,
because I'm just
really,
looking for the chat.
Yeah.
Mm-hmm.
What really emerges from so much of this is how does the arbitrator combine international public policy, international law obligations that affect the merits of the claims, and procedural fairness. And procedural fairness ratcheted up to the nth degree, because there are collateral proceedings where people are accused or may be accused of crimes, may be victimized and unfairly accused in their home state because the state needs to bolster its claim of corruption by prosecuting somebody for corruption, after all, right? It can be a very, very perverse circumstance. And the result is that the stresses on a tribunal from a procedural standpoint to deal with the matter fairly are very acute.
Yes, I don't think I can answer in a bit of a one black and white form. I would just pass on to Tatiana and then probably comments, as well as welcome any further comments or questions from the audience, because I think that's the Solomon's justice here in a way, which is required. But the institutional background is quite not really encouraging, because it's so diverse that at the moment the building blocks for a unitary approach, they're not there, I would think. But perhaps we'll hear Tanya.
Yes, I just wanted to briefly come back to your point, Alexey, about that the allegation of corruption is very often used by former USSR states, where actually they cannot control and they cannot control corruption in their own countries. So just briefly to mention that the famous case, Metal Tech versus Uzbekistan, where tribunal actually made finding of corruption and it dismissed its jurisdiction. And in this case, it's interesting. This case is interesting because there was a shifting of burden of proof in this case. So actually, the tribunal asked the claimants to disprove the allegation of corruption, and they found this evidence, which was advanced by the claimants, not reliable, and also the tribunal actually made findings about red flags in this case, and using this kind of lowering standard of proof. So, of course, like given the very limited time we have, the topic is extremely interesting and raise huge amount of issues, but you know where to start and where to stop.
I think probably given the discussion, perhaps is the issue as to whether we want to briefly identify our own opinion, because in relation to some very to some basic points like standard proof, I would say that I myself support a higher standards for international arbitration, because it's not actually the courts, it has a special a special function, and probably the burden is on the other party who alleges this. It cannot substitute state courts, and it has to be extremely careful in something which could undermine the nature of the international arbitration. Otherwise, it's a Pandora's box which you can open. It's already starts to open, and it will be extremely difficult for us then to fight with this ghost coming out of there. That's my short opinion. I don't know what Marc thinks about the standard proof, and probably one more question from the audience and we're done.
Let's hear from the audience. I'll hold my views. Let's hear from our participants.
Participants are referring this to us.
Oh, okay. I think that no fixed rule is going to be adequate in every circumstance, but I think a high standard of proof prima facie is very important. When, as will inevitably be the case, allegations of corruption are raised at the commencement of the arbitration as an objection to the jurisdiction of a tribunal and threaten to paralyze the system, there should be a very significant burden. On the other hand, there's always another hand, but you have the availability of proof and the access of the parties, including a state party, to proof is a circumstance that has to be considered, not only in the context of burdens of proof, but also in the context of whether adverse inferences should be drawn. What exactly are the sources of evidence available to the party asserting or defending against corruption charges without going into the process and using the process to gather evidence. It's a very difficult equation.
Also, it's very interesting, Marc, what you raised, that regarding the state's responsibility, so respondents' responsibility in this, when they raise allegation of corruption, what is their role? Yes, when they facilitated or supported corruption. So when corruption was made by state's official, yes, why would state receive protection? Yes, when state actually participated in this activity as well.
Yes, I agree. That's a very serious consideration, and it it brings us to this question, which was discussed recently, about that's whether a party who procured, even if a party procured the contract by corruption, whether it should be entitled to recover damages, to the extent the state or the other party had some benefit therefrom. As a general approach, it should not. But whether it's fair as such, especially given the convenient defense and the actions of the state, I would say definitely it requires further consideration and probably unification. But at the moment we are where we are. The tribunals, they try to effectively bridge a gap between the impossibilities of the formal position of the applicable law and the need for justice, especially in the international context, but these are only the contours, nothing more than the debate or some standalone arbitral awards. So perhaps this makes it all so exciting, so we can discuss this further and further, but in the interest of time and the fact that there will be a mock hearing shortly, starting as our organizers are writing to us, the virtual arbitration hearing will start in a bit of 10 minutes. We unfortunately will have to adjourn, and I thank everyone for their participation. I thank Tatiana, I thank Marc, thank all those who participated and were with us. Unfortunately, the format limited the possibility of a wider discussion, but I'm sure we'll follow up in due course. There's quite a lot to think and discuss. Thank you very much, and we wish you all the best to you at the next session today. Thank you.
Thank you.
Thank you.
Thanks
Bye.
very much. Thank you all.
Thank you. Bye.
Bye now.
Bye-bye.
Bye.